This is Adam Silva, our legal intern from McGeorge Law School. We're privileged to have his capable services over the course of the summer. He joins us in a long, distinguished line of Adams, having succeeded Adam Borchard. Adam Silva will be, a third year next year. Very interested in water law and resources management. And keeping in line with our tradition of updating you periodically on court cases that are pending or that have been decided recently that aren't necessarily Delta Plan litigation. And just a brief pause, the Delta Plan litigation is still ongoing, so unfortunately I can't report that that's over yet. But we do have an upcoming case management conference on July 18th. But we're still at the very early procedural stages on that. So Adam's here to update you just on a couple cases, and I'm going to turn it over to Adam Silva.
Thank you very much. Thank you very much, Mr. Stevens. Yes, like Mr. Stevens said, there's two recent cases that we'd like to draw to your attention at today's meeting. The first involves the constitutional principle of reasonable use and the public trust doctrine and how they apply to riparian users. First, you may recall that in the Delta Reform Act, specifically Water Code, Section 85023, it states that the constitutional principle of reasonable use and the public trust doctrine are foundational for Delta water management. The same principle is reflected in the Delta Plan. We would like to draw to your attention to the recent First District Court of Appeals case of Rudolph H. Light versus State Water Resources Control Board. You remember that this case involved the stranding and killing of 25,000 juvenile salmon in the Russian River after nearby riparian vineyards withdrew water at the same time to apply to their vineyards for frost protection. So while the Russian River itself does not flow directly into the Delta, there are several important points relied on by the court that are relevant for Delta water management, particularly regarding reasonable use, the public trust doctrine, and the adequacy of the environmental impact report prepared by the Water Board. So regarding the stranding, the State Water Board prepared an environmental impact report and ultimately issued Regulation 862. Regulation 862 delegated the monitoring and the construction of corrective action plans to local entities who would report to this Water Board and were subject to Water Board approval. Regulation 862 declared that the failure to develop a corrective action plan or properly monitor water levels or a diversion contrary to a corrective action plan would be unreasonable and would render the diverter subject to enforcement by the Water Board. Now, this subject is not new to California. You may recall that 40 years ago, in the case of State Water Resources Control Board v. Forney, the California Appellate Court upheld the board's authority to designate diversions for frost protection as an unreasonable use. This case confirms the principles in Forney by stating that the board's power to designate diversions as an unreasonable use extends over riparian and early appropriative water rights holders. So in this case, the Court of Appeals reversed the trial court decision and held, one, that the board was able to enact these regulations through its regulatory powers and through the pursuit of judicial and quasi-judicial proceedings. Two, that the board had the power to prevent riparian users and early appropriative users from using the water in an unreasonable manner. And three, that the board did not unlawfully delegate its authority by requiring the local entities to formulate the corrective action plans. So in referencing the prohibition of unreasonable use found in Article 10, Section 2, the Court of Appeals noted that the Water Board the Water Code vests broad adjudicatory and regulatory authority to the board, coincident to that of the legislator. This means that the board will have very broad power in terms of managing what is or is not a reasonable use when it comes to the Delta water. In terms of the public trust doctrine, the Court of Appeals cited to the National Audubon Society case when it held that the state has an affirmative duty to take the public trust into account in the planning and allocation of water resources and to protect the public trust uses whenever feasible. And in discussing the adequacy of the EIR, the Court of Appeals stated from the case of California Oak Foundation versus the Regents of the University of California that the overriding issue on review is whether the lead agency reasonably and in good faith discussed the project in detail sufficient to enable the public to discern from the EIR the analytical route the agency took from the evidence to its ultimate action. So again, while this case does not directly impact the Delta, the underlying principles are relevant to the management of Delta water, as stated in the Delta Reform Act and reflected in the Delta Plan. Now, the second case involves temporary water transfers and their compliance with the Federal National Environmental Policy Act, or NEPA. You may recall in the Delta Plan regulations, temporary or up to 1 year water transfers are included until January 1st, 2017, among certain categories of projects that don't meet the significant impact criteria for covered actions. The Council contemplated that any extension beyond January 1st, 2017 would be based on recommendations from a joint DWR State Water Board work group on water transfers, including measures to streamline transfers, protect water rights and environmental resources, and to address potential issues with recurring temporary transfers and to promote better transparency. A case recently filed in the U.S. District Court for the Eastern District of California challenges on environmental grounds a significant proposed north of Delta to south of Delta water transfer to be facilitated by the Bureau of Reclamation. Depending on how this case is ultimately decided, it may be informative for the purposes of the Council deliberations regarding water transfers under the Delta Plan regulations. So the case, titled Aqua Alliance and California Sport Fishing Protection Alliance versus United States Bureau of Reclamation, involves a proposed water transfer for the summer of 2014 of up to 175,226 acre-feet of water, primarily from the Shasta Reservoir through the Delta, to buyers within the San Luis and Delta Mendota Water Authority, which encompasses portions of San Joaquin, Stanislaus, Merced, Fresno, Kings, San Benito, and Santa Clara counties. In facilitating the proposed transfer, the Bureau conducted an environmental assessment under NEPA and ultimately issued a finding of no significant impact, meaning they were not required to conduct an environmental impact statement. Now, the plaintiffs are organizations made up of members who live, work, and recreate in the Delta, as well as rely on Sacramento Valley groundwater for their livelihood. The plaintiffs have three main allegations. The first is that the Bureau relied on insufficient and improper data when making its finding of no significant impact. After the Bureau issued its finding of no significant impact, the State Water Board and the United States Geological Survey issued new information that showed the environmental conditions surrounding the proposed transfer were in a much more precarious situation than originally thought. So the plaintiffs alleged that the Bureau should have had to have gone back and prepared a supplemental environmental assessment or a full environmental impact statement, taking into account these new considerations, or taking into account the new information provided by the Water Board and the USGS. The second allegation was that, contrary to the Bureau's opinion, the proposed transfer does constitute a major federal action under NEPA. Because NEPA requires a federal agency to prepare a detailed statement discussing the environmental effects of and the reasonable alternatives to all major federal actions significantly affecting the quality of the human environment, the plaintiffs contend that the Bureau's finding of no significant impact was insufficient under NEPA, given the size of the proposed transfer, the involvement of the Bureau, and the potential environmental impacts. And finally, the plaintiffs allege that the Bureau failed to take a hard look at the proposed project's potential impacts on the environment, particularly regarding groundwater levels and the Delta smelt. The plaintiffs are asking the court to vacate the Bureau's initial findings as arbitrary and capricious, as well as prevent the defendants from approving any water transfers encompassed by this project until the Bureau can go back and consider the newly released information. So we will monitor this case and keep the council updated as new information becomes available.
Thank you.
Adam, thank you. Any questions of Adam?
Nice report.
Yeah,
Good
very
job.
comprehensive.
Thank you.